Hello, good evening. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead, put your questions in the comments now so that I may answer your questions. I also have a great topic for you today, and it's congratulations, you've gotten your approved I-130 petition. Now what? Right? There is the misconception that once you get an approved I-130, it's all over. You're going to get your green card and everything is going to be great. Unfortunately, that's just about halfway through your process. You still have the other part of your process to complete. Now, let me backtrack a minute and let's talk about what is the I-130 petition. The I-130 petition is that application that your U.S. citizen or your legal permanent resident relative is going to file for you to obtain permanent residence. They have to first file it in the United States. It's processed, and there is a decision made on it at the USCIS. The purpose of that petition is to establish the family relationship that qualifies you for permanent residence. So that's just the first step. Once they've approved it, meaning they've established that you qualify through your family member, they're going to move the petition on to, if you're outside of the country, they're going to move it on to the National Visa Center. The National Visa Center is where they are going to make a final decision on your application. So the National Visa Center is going to forward it to the embassy. The embassy is going to schedule your interview, and that's where they're going to make the final decision. So as you can see, based on that, the approved petition is about 1/3 of the way. Once you get the approved petition, if you're outside of the United States, it's going to be sent within a matter of days or weeks to the National Visa Center to be processed further. The National Visa Center is like the middleman between the petitioner, the immigrant applicant, and the U.S. Embassy. So they get in touch with my cases, they get in touch with me as the attorney, and then we work to gather the additional documentation that they need. The number one thing you're going to do is you're going to pay for the application to be processed. There are two applications that you have to think about at this stage, and you're not going to be able to move forward in the process until you make that payment to the National Visa Center. It's going to be the payment of the immigrant application, and so you call the immigrant fee, or the DS-260. And then you're going to have to pay for processing of the Affidavit of Support. The Affidavit of Support is a document that you will have to submit as the petitioner. So if you're the U.S. citizen or legal permanent resident, you're going to submit the Affidavit of Support along with the evidence to show that you meet the income requirements to support your relative. So at that point that you've made the payment, you submitted the application, submitted the required documentation that they're asking for, and submitted the Affidavit of Support, all being well, they will go ahead and they will say that you're documentarily qualified. That means that they don't need anything else from you. They see that you've provided all they need, and then they're going to work with the embassy in your country or the country where you want to go ahead and do consular processing. They'll work with the embassy to find an available date to fit you in. So that sounds like a straightforward process, right? And unfortunately, right now, that's not necessarily the case. There can be some hiccups, and I find that the I-130 is taking a while to get an approval on that I-130. That's the frustrating part. It's taking over a year right now. Once the approved I-130 has been sent to the National Visa Center, the next thing is that it's going to have to be processed by the National Visa Center, and they themselves are overwhelmed because the National Visa Center, they're working on cases all around the globe. And what I'm finding is that where they used to take maybe a week or two to get back to you to tell you that you've submitted all the required documentation and you are now ready to be scheduled for the interview, I find that individuals who, especially those individuals who apply on their own, they are really taken on a ride, because when you submit documentation, if it's rejected, what happens is that it's rejected, they send you a rejection, you correct the rejection, you submit the documents they need, and then it takes another 3 weeks for them, not 3 weeks, 3 months for them to review it and then tell you whether they need anything more or whether they will accept your documentation. And so you find that you're going in circles and circles and circles. You really do have to understand your process, understand what's required of you in your application to get this right. That's another benefit of getting an attorney, hiring an attorney to help you through the process, because the National Visa Center, if you're not understanding the requirements, if you're not getting it right, then you're going to be spending a year or two just trying to exchange documents with the National Visa Center, especially with the current backlog. There's that. Then once you are documentarily qualified, embassies are backed up right now, and we're seeing wait periods for interview dates from 3 months to a year or over a year. So that's another thing that you have to expect. You can't expect that once you're documentarily qualified, you're going to be issued an interview date right away. It used to be that within a few weeks, 1 to 2 weeks after being documentarily qualified, you would get that interview at the embassy. Unfortunately, previous backlogs and then worsened by the pandemic has made the situation really dire. I mean, to the point of crisis level, where people have to be waiting over a year just to get an interview date. So that is just giving you, this is an idea of what you should expect after you have an approved I-130 petition and you're doing it at the consular. You're going through consular processing, meaning you're outside of the United States and you're going to finish your process at the embassy. Now, usually if you've started and you're in the middle of your consular processing, you're outside of the United States, you're going to have to see it through. If you're currently in the United States and you meet all the conditions, adjustment of status may be for you here. Adjustment of status is the process of applying for permanent residence while you are staying in the United States. The additional benefits are you get to stay with your family, you get a head start on life in the United States, you get a work permit and even a travel document if in case you need to move back and forth between your country and the US for some reason. You do get those additional benefits going through adjustment of status. Adjustment of status is backlogged right now. You could expect an 18-month to a 24-month process still, but you get to stay here and get a work permit while you're doing it. Now, you do have to meet certain conditions. Not everyone who qualifies for permanent residence is going to qualify for adjustment of status. First of all, you can't pack your bags and say, oh, hell yeah. The benefits of adjustment of status outweigh the benefits of consular processing. I'm heading to the US to file my adjustment of status. You can't do that, right? If you're entering the United States with a visa, temporary visa, for the purpose of applying for adjustment of status and staying in the US, that can be, you can end up with a misrepresentation charge. That's why I said previously, if you started with consular processing, you're in the middle of consular processing, you can't just come to the US with that intention. Now, it's different if you're already here and you meet all the conditions while you're here and you want to decide while you're here whether that's a feasible option. That is within your right to make a decision after you've entered the United States. Now, if you are being petitioned for and you have a current priority date, so you have a current priority date, you have your approved I-130 petition, and you're currently maintaining legal status here, then adjustment of status may be for you here. It's always best before you do anything to get personalized legal advice, because remember, the information that I'm providing here is not legal advice, personal legal advice to you. It's general information. But those are the general conditions that you'll have to meet. If you're here, generally, you do have to submit this adjustment of status with the approved I-130 and your current priority date while you're maintaining legal status. But there are some exceptions. Exceptions to the rule would apply to immediate relatives of U.S. citizens. So even if you end up overstaying your visa, you may still qualify for adjustment of status. If you cross the border without permission, though, that's going to be a different story. You likely will not qualify for adjustment of status. Also, VAWA applicants. If you have right now the T or the U visa, adjustment of status could be for you, and you could stay here and apply for adjustment of status. But you have to make sure that you understand whether you meet the requirements in your particular situation. That's what I'm here for. I'm here to make sure that my clients successfully get through the process. And so you can call, schedule an appointment, and then we can talk about your situation and then get started. I can represent you. Now I'm gonna go to questions. Which state are you practicing in? So I practice in Florida. I am also barred in Minnesota, but as a U.S. immigration attorney, this is the great part about being practicing in a federal area of law, is that this is a national practice. So my practice is national. I represent clients in all 50 states. I have my clients all over the country. I have my clients all over the globe. So we're not limited by state lines, not limited by borders. We do, as immigration attorneys, we have to file petitions across state lines at different USCIS offices all over the country. And so we work with USCIS companies, USCIS offices, U.S. immigration courts all over the country. We work with U.S. embassies all over the globe. So no matter where you are, if you have a U.S. immigration issue, I'm here for it. I'm here to help you through the process. Now, Yatin Patel, I heard they're working on all cases now on the news. So the USCIS just released an article stating that they are taking steps to reduce the backlog. And so they are trying to, first of all, they're trying to implement automatic employment authorization. They're trying to keep the processing times within 6 months for certain applications, like the I-130, like the naturalization application, like the VAWA application. And they're also going to be expanding the premium processing for the work permit applications along with the employment-based applications. So we will see, but they are really taking some steps now to make this happen, to reduce the backlog and to get the system working again. And we'll see if that, they've also stated they're expanding staff, they're implementing new techniques within the agencies to speed things up. So let's see, because it really is at a crisis level here. How can I find my cases move from one service center to a different one? So sometimes they'll notify you, and then sometimes you can call and you can check whether it has been moved, what service center it's at. Hey, I have a question. Can a Jamaican citizen with a U.S. green card fly on an expired visa? So if you have a U.S. green card, you should not need a visa. So there's something going on here. that you will definitely need to make sure you get legal advice on here. If you have a green card, the green card should be enough for you to fly into the United States. However, if you have been outside of the United States for more than 365 days or more, then that document may not be a valid travel document to enter the United States, and you may face some issues at the airport. You may get a notice to appear in immigration court to defend your permanent resident status. Because remember, once they let you into the country, you will be a permanent resident until you're told otherwise by an immigration judge. And so, the first thing is, if you have that situation, get legal advice. There is a way to apply for what's called an Sb1 Visa, and that is for returning residents to come back into the United States and then reestablish your status as a permanent resident. You do have to meet certain criteria, like you have to show that you did not intend to stay outside of the United States. Maybe something happened, you got sick, or a family member got sick, or there were circumstances beyond your control. You do have to show that you continue to maintain your ties in the United States. And then you have to, when you come back to the United States, you have to make sure that you follow through to reestablish your residence. So keep that in mind. Get legal advice. Your situation is definitely out of the ordinary. If you have both a visa and a green card, you need to get legal advice. Great questions. Keep those questions coming. That's why I am here. So I got my citizenship now, being told I have to file another form for my daughter, costing about $1,200. Purpose-driven 43. I have a little tip for you. You don't necessarily have to apply for that. So it's called the N600. You don't have to. You can apply for your daughter's citizenship. Now, if your daughter is under 18 and she has, that means she's automatically derived citizenship as soon as you became a citizen. And as long as she's here, she's in your custody, she's here lawfully as a permanent resident. Now, you can apply directly for the passport, and the passport is much cheaper. And, of course, it can be used as evidence of US citizenship. Now, you do have to get in touch with the office, the passport office, to understand what documents you need to provide. Of course, you'd need to provide proof that you're now a citizen, proof that you are the parent, proof that your daughter is lawful here and that she has indeed derived citizenship. And in a case like that, they will just issue the passport. So that is one tip of the day here, but keep in mind, purpose-driven, that I'm not your attorney. I haven't reviewed your case. I don't know. I haven't confirmed whether your daughter has indeed derived citizenship from you. But in my cases, clients' cases, where their child has derived citizenship from them, we just go straight to applying for their passport. So go ahead. Get personal legal advice, though, to confirm that this will work for you. I expedited my IR2 NVC case a month ago and didn't get a reply. So if you requested an expedite, sometimes they do take a while. Remember, the National Visa Center takes 3 months alone to reply to any requests, any communication that you may have. So, unfortunately, that does apply to expedite requests as well. Unfortunately, they will reply. They will pass this on to the embassy, and then they'll give you information. If I overstay on a visa, how long can I return home after marriage? So if you overstayed on your visa and then you get married to a U.S. citizen and you qualify for adjustment of status, then you do have to stay in the United States for the adjustment of status process. If you leave, especially without a travel document, they can see this as you're abandoning your adjustment of status process, and you'd have to wait it out in the country, outside of the country. but keep in mind that you'd face additional complications as a result of the overstay, depending on how long you overstayed. So, Angel, make sure that you get legal advice. Can't stress enough. Don't do any traveling until you get personalized legal advice about how you need to approach your situation. Great questions. All right. I am pretty much done with the topic that I came to talk about. So remember, when you have an approved I-130 petition, it's about 1/3 of the way. You then if you're outside of the US, you're the immigrant, it has to go through the National Visa Center. And then after the National Visa Center handles your case, it's going to go to the embassy. Right now, there's a backlog in wait times for every time you submit your documentation. If you get it wrong, you're going to have to wait months and months and months. That's another benefit of getting an attorney involved, because the attorney ensures a smoother process, reduces the mistakes and the errors, and make sure that while an attorney cannot guarantee that you'll have a shorter process, they can make sure that they can avoid unnecessary delays in your case. I see a few more questions, so I'm going to get to those questions. Let me remind you that I'm also on YouTube. So feel free at any point to put your comments on YouTube. I will answer. I'm monitoring the comments on both platforms. Do you have to be in an institution such as a school to apply for a work and travel visa? So you do have to be affiliated with an employer, or you have to qualify in some way to work here, and you say apply for a work and travel visa. For visitor's visa, you do need to show strong ties to your home country. You don't need to show that you're attending school here or that you have an employer, but you do have to show that you do have all of those things in your home country for the visitor's visa. When you're dealing with a work visa or student visa, yes, definitely you'll have to show that you qualify through a school, an institution, or an employer. My husband filed for me and it's been 2 years, still haven't gotten an interview date. Exactly. So that's exactly what we're talking about. NOV, it is backed up. If you feel like you need assistance through your process, make sure you get legal advice. Check on your case, make sure there's nothing pending. If you overstayed because of COVID, will there be repercussions? There may be. I wouldn't be able to guarantee that there won't be. That may serve as a great justification for why you ended up staying outside of the country, but you may have to go through a process. And that's where a Vici schedule an appointment, let's talk about your issues, and then get started on representation to fix your situation. So I have wait for my to be citizen to apply for. So you're waiting for your spouse to apply for citizenship, to apply for the I-485. So JASA, that may not be necessarily be the way to go. Schedule a consultation. Let's talk about your situation and then figure out how you can move forward. Because you don't necessarily, I think you're talking about your spouse. If not, then that may be a different situation. But let's talk in a consultation. Go to the link in the profile. It's going to take you to the website. Scheduling coordinators are available right now to take your call and schedule your appointment. You can go to the website. You'll see the phone number. You'll see the online chat, and you will see the contact form. All three will lead to a scheduling coordinator who will be more than happy to assist you with scheduling your appointment. Is a permanent resident card and Jamaican birth certificate considered as the correct requirement? So Miss Exotic, I'm not understanding to enter the island. So I'm not a Jamaican immigration attorney, but usually when you're traveling, you do need to travel with a passport and your permanent resident card. Right. So Ankush, can you explain something about the I-751 waiver? So go ahead and put your question in. As long as I'm here, I'll answer it. But if not, you'll have to catch me tomorrow, or I'm heading on over to Instagram. You can talk to me there as well. I'm the immigration attorney on Instagram. So I'll be there in a minute. So just hop on over there and ask your question there if I have to close out and I don't get to your question. I am going to be back. I'm on here around 4 p.m. Eastern time. So you can join me tomorrow at 4 p.m. Eastern time, where we can continue the conversation. I'll bring a topic. You can bring your question. So Ankush, yes, there's something called the I-751 divorce waiver. You do have to show that your marriage is bona fide in the case that you do have the divorce or you qualify for the divorce waiver. You still do have to show that your marriage was bona fide, even though it didn't work out. You can apply for these waivers at any point. And there is a backlog, so that it may not hurt to start applying now, because that way you get ahead of the game. And yes, Ankush, absolutely, that is an area that I focus on, and you are welcome to call, schedule a consultation, and then we can talk about your situation and get started on that waiver. So I can't stress enough, I represent my clients in all 50 states and the globe. So no matter where you are, I can assist you with that. Let's get on it. Don't make it sit there. Get on it and get started. All right. So I'll see you in a minute on Instagram. I'm the immigration attorney. You can go ahead and follow me there. Most of my content is on Instagram, videos throughout the day with tips, updates. And so you're welcome to join me there, to look out for those updates, and then to join me live at around 4:30. So I'm late, so I'm going to head over there now. Go to the link in the profile if you want to schedule a consultation. I'll see you tomorrow. I'll speak with you in a consultation. Have a great evening. Bye-bye.